Thank you. Hi, everyone. I'm Jeremiah Kaufman. I'm from DLA Piper, and I'm glad to be here. I generally work on commercial leasing in my practice every day. And joining me is Bisma. Do you want to introduce yourself?
Hi, everyone. I'm Bisma Jaffer, and I work at Lawyers Committee for Civil Rights. I work in the Legal Services for Entrepreneurs program, where we offer direct legal services to small business owners, and I mainly work in commercial leases.
Okay, so I think to kick things off, if you just go to the next slide, we're going to just kind of, I guess the first thing is disclaimer. This is not legal advice. We're just going through general information on commercial leasing for your background knowledge. I see there's a question about, are we available for consult? And as with Anna mentioned, you can contact LCCR for direct help on specific issues. Okay, next. So today we're going to go through two concepts. Bisma and I will take you through two big picture ideas. First, I'll start with best practices when dealing with leasing issues. So this will cover issues you may be having with your landlord, how to think through them, how to talk through them, how to negotiate some of those issues that might come up, and kind of parallel with that, any of those issues would also apply as you're negotiating a lease and thinking forward into the future about what things might come up down the road. And then Bisma will take you through the eviction process and kind of what has to happen and all the steps that need to happen or are a part of that process, so that you have an idea of what you're working with if you can't work out things when negotiating your issues with the landlord. Okay, next. Okay, starting best practices when dealing with your lease issues. So you're dealing with your lease and you have an issue. Could be of back owed rent. Maybe your premises is in bad shape. Maybe the landlord isn't providing electricity, or he's doing the landlord's doing some kind of construction in front of your entrance and you can't get in. There could be all kinds of issues. So you're having an issue with your lease. Now what? We'll talk through these best practices and, as I said, concepts to think about in lease negotiations. Next slide. First step, you want to pull out your lease and take a look at what's written down. What's written down really matters when it comes to your lease. So first, defer to the provisions in your lease. Take a look at anything that you've already written down. Don't forget the exhibits, the appendices, the addendums. If your lease is actually a sublease under another lease, make sure you look at your sublease and the master lease. You want to check all the documents. So for instance, if you've had a lease for multiple terms, a really long lease, and you've renewed it and renewed it and renewed it, make sure you go back and look through the original lease and all the extensions so that you understand you might have. Maybe you had somebody negotiated them years ago, still exist under your lease. It's get all those documents and what's contained in there and what you can lease. You're leasing from somebody on a vermin and you've been there for a while. It's not a great situation, but it's actually not great for you or the landlord. But for you to stay in and enforce any rights, you really want to get something in writing. If you want to have a lease or rights under a lease for greater than 1 year, under the law, it has to be in writing in order to be enforceable. Otherwise, it simply isn't enforceable, and you're going to have a hard time enforcing anything under your lease. I'm going to go through a couple items, but at the end, then I'll talk through some hypotheticals where we'll review a couple examples of provisions that you might find in your lease and how to think through them. And how to think through interpreting how they're written, because it'll apply to multiple examples, not just these two, but we'll go through if you have repairs that you need to do and what your repair provision might look like in your lease, and if you're renewing a lease and what those provisions might look like. Okay, next. Okay, so when you're looking at your lease and you're looking through all those documents, there's some high-level items to keep an eye out for that might come into play, especially when you're dealing with money, back owed rent, different things like that. Keep an eye out for common area and other shared expenses. These are often written as maybe CAM fees, common area maintenance fees. They might be denoted as additional rent. So you might have your base rent or your monthly rent, and then you'll have these common area fees or some kind of language that says you may owe additional rent under these things. You may have abatement or other rights. So taking a look through your lease, you might find that your rent might be able to be reduced, or you might have damages and have a right to stop certain things if you can't access the building. If the landlord cuts off services, or you don't have utilities, or maybe they stop there's sanitation issues or janitorial issues in general. What you want to do is look through your lease and be on the lookout for provisions that might guarantee the landlord won't be liable for some of those disruptions. So if there's something in the lease or somewhere along the lines that says, if you don't have electricity, it's not the landlord's fault and you can't deduct rent, or you can't abate rent, then that kind of provision is going to protect the landlord. But in general, if the lease is silent, and as a general concept, you have a right of an implied covenant of quiet enjoyment, which applies to all commercial tenants. So if your place is untenantable, you can't enjoy it, you may have rights to offset or abate your rent. Okay, next slide. Also keep an eye out for force majeure clauses. This is specifically, the clause would actually probably say force majeure, or it may say if an event of force majeure occurs, and then it'll describe what a force majeure is, and that may be, it'll be a long list of things like riots or supply chain issues or pandemics or whatever. It could be a lot of things. Sometimes if there's a force majeure clause, they may not require you then to keep paying rent if there's a force majeure. So if there was a riot in the streets, you may not have to keep paying rent, or different things like that. So you have to look at the specific clause and see how it's worded, if it applies to your particular situation at the time that you're having some issues. Commercial frustration of purpose is just like, this is a concept. You're not going to necessarily find it in writing in your lease, but what you look at in your lease is to say, this lease says I can only run a hair salon, or this lease says I can only run a restaurant, but it's technically not possible to run a hair salon here anymore, or it's not possible to run a restaurant. The city won't allow it, or the permitting won't allow it, and it's impossible. Then there may be some arguments that the whole purpose of the lease has been frustrated and you are no longer obligated under the lease. So you should be able to have get out of your lease or terminate, or come up with some opportunity to deal with whatever issues you need to get out of it, or to change your usage or whatever. For buildings with multiple commercial spaces, like food court or shopping mall, there may be lease clauses where it requires the landlord to have a certain amount of occupancies in order for you to be obligated to pay rent or to stay in the premises. So for instance, sometimes, if a whole strip mall, 5 out of 6 of the shops go dark, you may have rights under your lease, and you should look at this, or you can negotiate them if you're looking at a new lease, where you can say, hey, if nobody else is here, we don't have to be here either. We can get out of our lease. And then just another thing to keep an eye out for is your right to assign or sublease the lease if you need to get out of it. So next slide. And I see we have a question, but I think we'll get to that around the eviction discussions. Okay, so second step, after you've looked through your lease, you've looked for kind of key provisions that might have to do with the issues you're dealing with, or your particular situation, so you know what you have, then you need to start negotiating with your landlord. Start by explaining your situation with the landlord. Explain whatever hardship you're dealing with, or if you have an inability to pay, let's say, back rent, or possibly point to some issues with the landlord's behavior. Again, maybe they're doing construction in front of your front door. Maybe they're they negotiated in bad faith and tricked you and put some things into the lease that you didn't agree to, or maybe they violated some provisions of the lease and they themselves aren't following them. When you go talk with them, have those in hand and start with a request that's going to be better than what you might settle on. So start with a bigger request than what you ultimately need. Okay, next slide. Okay, so to give you one example, if you have back due rent and you owe, let's say, a couple months worth of rent and you are trying to figure out how to pay it, you don't want to be evicted, some possible negotiation ideas, some creative ways to get around this issue rather than saying, hey, we just have to pay back rent and there's no other option. There are some creative options you can think about. One idea is, obviously the first and easiest, is that you ask the landlord to just forgive the back owed rent with the promise that you continue paying rent moving forward, maybe even with the payment for the current rent, if they'll forgive the back rent. Believe it or not, that may sound like you're not giving them anything, but in today's market, with the really bad leasing market, some landlords, that would actually be appealing, because if you left, they may get no rent moving forward, and it may take them a long time to fill in their tenants. And so they actually might look at that as a good offer, where you say, listen, you forgive us, we'll keep paying, we'll move forward. Let's just let it go. Again, you want that in writing. Any of these kind of things that you can work out with the landlord, you're going to need in writing. But that's one idea. Another idea, the landlord won't give up the back rent, but maybe they're willing to convert it to a loan that's paid over a long term. So you could start paying rent moving forward and pay small amounts on the back rent due over time. Another option might be you offer to sign a lease amendment with the landlord with a whole new rent scheme in exchange for forgiving your back owed rent. So you could think about things like converting your rent, maybe it's whatever it is, $2,000 a month, and you convert it to some sort of percentage rent. Percentage rent would be more applicable if you are a retail store or something like that, where you're selling products or services, and then you agree to some kind of percentage rent of your sales. So you say, instead of just giving you $2,000 flat, we'll give you $500 and 5% of our income when we go over $10,000 a month. And then you would have to probably prove to them that you generally make more than $10,000 a month, and then maybe they would agree with you to forgive the back rent and come up with this new rent scheme going forward. Another option is they might consider an extension of the term at a higher rate. So you say, listen, well, if you forgive our back rent, we'll extend our lease another 3 years and we'll do it at a slightly higher rent. It was only going to be at 2%. We'll increase it to 3%, 3% higher rent, and for a longer term. That may be appealing to landlords. It's a rough market. They can get somebody in there. They know you'll be in there long term. That may be appealing to them, and that may be worth forgiving your back rent. And finally, a last thing is you may be able to talk them into simply taking the security deposit that they have and applying it towards the back rent, and giving you a delay on repayment of anything additional. Okay, next slide. As I mentioned, keep all your communication with the landlord or the property manager in writing. If something's discussed over the phone or in person, make sure you follow up with them with an email of the contents of the conversation, so that you have something in writing showing what was discussed and when it was discussed, whatever your issue is. Now you can keep, as I mentioned, you can keep all these negotiation points in mind when you're working on a new lease. And when you're working on a new lease, it's highly recommended that you do your research on the building or on the landlord. If the landlord comes back to you and says they can't do something, they can't provide a service, or they can't do a creative rent structure or something else, and you've talked with the other tenants in the area or tenants of this landlord, and you find out that they have done this or they can do it, it's going to be a powerful negotiation leverage for you to say, this is something we know that you've offered to other tenants. We think it's fair to offer it here, and we're giving you a good offer. So do your research when negotiating with the landlord. Okay, next slide. Okay, and we'll end this section with a couple hypotheticals and walk through. This will tie together some of the different ideas we've been talking about. So you're looking through your lease, you have an issue. Your property has a leak in the roof and the landlord hasn't fixed it, and it's interrupting your business. So you take a look through your lease to figure out what rights do you have. As you're looking through your lease, you find this following provision. It says repairs and maintenance. The parties agree that tenants shall be responsible for any costs related to the repair or maintenance activities of the premises, unless such repairs or maintenance is required in whole or in part because of any negligent or wrongful act or omission of the landlord, in which case tenant must notify the landlord within 10 days the need for repair or maintenance is made apparent for the landlord to pay the cost of such repairs or maintenance. Okay, next slide. Okay, so the first question, you looked at that provision, you say, who is responsible for the leaky roof, repairing it? So under that provision that we read, you are responsible for repairing and maintaining the premises, which would include, in this scenario, potentially the roof, unless the issue was caused by the negligent or wrongful acts of the landlord. It could be an issue determining the cause of the need for the repair. So it may be an issue to figure out, was this a landlord negligent issue, or did the landlord do something that caused this? Or is it just simply the roof is old, wore away, and it's our responsibility? In this scenario, you could imagine something where the landlord may have been on the roof in the last year and had something installed, or maybe an antenna or a satellite dish or different things, and they may have punctured the roof that caused the leak. That would be an example of the landlord's negligence or wrongful acts, where the landlord would be responsible for the maintenance. If it's the landlord's fault, you still have to notify the landlord before the landlord is actually responsible for paying. And you have to notify them with 10 days notice. So they don't have to respond unless they've had notice from you and 10 days have passed. So again, go back to the lease and see if there's a provision on how to provide notices. You can't just, likely, you cannot just text the property manager and say, hey, the roof's leaking and it's your fault, please fix it. The landlord legally may not have to respond to that kind of notice. So again, we're following the provisions of the lease and what's written there. If we go back and we look at, okay, what kind of notices do we have to provide? If you click on the next slide, an example of a notice provision. So typically leases will have a notice provision, and the notice provision, this is a very typical one that you would see, may read like this. Whenever it is required that any notice be given hereunder, the same shall be sufficiently served by depositing the same in the United States mail certified and return receipt requested, postage prepaid and addressed to the addresses followed set forth below. As I said, if you communicate with your landlord via phone or email or in person, you still want to follow up with an official notice under the provisions of the lease in the format agreed to under the lease. So, and this is going to apply to all notices, whether you're terminating the lease, whether you're exercising an option to renew, whether you're doing anything else. You always want to follow the notice provisions and make sure, yeah, you may have called them or talked to them and you know that they know what you want, but you want to send an official notice so that you follow the lease and you have legal rights then under the lease if they don't respond. So in this scenario, you need to send by United States mail, and it needs to be certified, return receipt requested, not just regular letter in the mail. So you have to do all those extra things. And then send that to the landlord with notice. Then you have proof of notice. And when the landlord doesn't respond in 10 days, you then will have rights to look at when the landlord's in default, what are your rights under the lease? Okay, next slide. Okay. Okay, I think I'll finish this hypothetical, and I think I saw there's a question can address. Okay, so one more example to give you is a lease renewal option. So hypothetically, your lease is your lease is coming up, your term is ending, and you're interested in renewing your lease before it expires. So go back to your lease. Does the lease include any option to renew or an addendum that has an option to renew? Here's an example clause. Provided tenant is not then in default under any terms and conditions of this lease, the tenant shall have one option to extend the term for an additional 5 years. Tenant must notify the landlord within 30 days, but not more than 90 days before the expiration of the lease to exercise the option to renew. So again, look at your notice provisions, find out what steps you have to take to officially notify them. If this kind of provision is in your lease, you will be able to exercise the option to renew. You do not need the landlord's permission to exercise the option. You already have the option. You just have to make sure you follow the terms and correctly notify them, and then your lease will be renewed. So, don't get confused in this kind of scenario. You don't have to go bargain with the landlord or negotiate with the landlord, or, if they try to negotiate with you for better terms, this is actually a great thing for you to stand on, to have some leverage to say, well, we have the right to renew as it says in the lease. We don't need your, this permission from you. So if you want to change the terms, we want to change some other terms in our benefit if we do that. Otherwise, we're just going to renew the lease as it is. Okay, next slide. If you do not have any options to renew, then potentially you just request your landlord to be available to negotiate a new lease. This means it wouldn't necessarily be a renewal. It could be an entirely new set of terms, new rent, new length of time for the lease. It's a whole new lease. So when you're negotiating a new lease, ask for things you need or want, things that have come up previously as issues, keep them in mind, and keep in mind these ideas that we've been talking about under the best practices. And we just listed a few examples of things that we've seen that are helpful for people to ask for, giving you some flexibility. Maybe you want to negotiate for the ability to terminate early, or the ability to close your doors and not pay rent if there's an emergency like a COVID shutdown, or maybe there's specific repairs and responsibilities that you want to put on the landlord, and you need, maybe they have those repair options before, but no hard deadline under the lease, and maybe you're able to put a new hard deadline. If there's a repair issue, they have to respond within 2 weeks, or else they're in default. And then what are your options if they're in default? Can you pay for it and take it out against rent, or terminate the lease? You may want to consider things like an arbitration and mediation clauses, where they have to arbitrate before filing anything with a court, which gives you some time to talk with them and negotiate. And like I said, some services maybe you want provided that they weren't providing, or maybe they didn't provide them well, utilities, electricity, HVAC, things like that. Okay, next slide. Okay, so that was this part, and I think I'll take a look at these questions here for a minute if I have time. But then Bisma is going to follow up with what happens when your leasing issues don't resolve and you're not able to negotiate with the landlord and come up with a good resolution, and it ends up with a unlawful detainer lawsuit, which if you get a notice about one of those, if you get a 3-day notice, make sure you contact an attorney immediately, and again, Bisma will take you through that. Okay, so what are the questions here? I haven't been looking, but Anna, if you've looked at them, are there ones I should jump on, or?
Yeah, I mean, I think we had one about sorry about that, the background noise. Having can you be evicted after having filed for bankruptcy? I don't know if you want to. Oh yeah, that would be later.
Yeah, so I mean, I can just real briefly, in terms of bankruptcy, yes, often actually bankruptcy is often a trigger to for terminating the lease. So it depends on, again, you want to go back and look at your lease terms, but a lot of leases actually have a clause built in that filing for bankruptcy is an event of default, and then they have all the rights under the lease for an event of default. Okay, we've tried renegotiating rents with extending terms into the future years. However, with the new normal on SF, with a return to offices at 31% and not sufficient for new normal levels of business. Now what? Renegotiate when not able to pay the negotiated rents and camps. Yeah, maybe you might be able to take advantage of whatever the situation is. I mean, yes, SF is in a really bad spot, and if your landlord is hurting, yes, you might be able to continue to renegotiate. I've seen landlords, I mean, a lot of landlords, they're like you, they're trying to survive. It depends. A lot of them, if they are a small, like a mom and pop kind of thing that own a building, or it was handed down over time, they may have mortgages themselves and certain limits on what they can and can't do. So you have to keep that in mind when you're negotiating with a landlord. And frankly, even when it's a big landlord, like a big investment company or something, often those buildings are tied up with big mortgages, and the lender actually has more control than the landlord. So often you're negotiating with the landlord, who's then seeing if the lender will do anything. And often the lenders won't do anything. But I would say in San Francisco at this point, lenders are actually open to reasonable negotiations. So push your landlord to consider your what you need, and maybe they'll be able to do it. Okay, and then I think there was one more here. Thank you for holding this webinar. In my community, there's a situation in which the commercial landlord is not cooperating with tenants' business needs for a particular permit. There's reason to believe this is the result of racism. Unfortunately, do you have some thoughts to share? I realize that this is a lot to consider. Just that why I am part of my local NAACP, which is how I heard about this situation. The tenant's business filed a complaint with us. The landlord's not cooperating with their needs for a permit. I mean, again, it's almost like I would go back to the lease. What's written in your lease? It's almost always the question, because leases have to be written down in order to be enforceable. The language in the lease is often determinative of all kinds of issues. In this issue, what comes to mind is when we were talking, one of the earlier slides, we mentioned the concept of frustration of purpose. And it's possible here that if the point of the lease, if it says the use or something is, whatever it is, the examples we gave were salon or a restaurant or something, and then you cannot get a permit to use it for the permitted use, then that may be a way. Well, you may have an option to get out of the lease. It may be hard to enforce the right to force them to get the permit if they don't have a requirement in the lease that they have to take reasonable actions to help you. It's going to be tricky if the lease is silent. I know you said it may be due to racism, but there are plenty of commercial reasons why a landlord may not want to get a permit for a specific use, and unfortunately they may be able to hide behind that. So I think you're going to be looking at more, can we get out of the lease, or what other leverage do we have to get something else we want? The permit was previously not an issue because the city issued it without getting permission from the landlord. It's an entertainment permit for live music. Historically, previous tenants have operated the space as a live music venue. Yeah.
Jeremiah, I think what we can do is we can have this participant and others as well that have more specific situations go ahead and register for either our legal clinic or our longer or short-term support, where we can have an attorney review their lease and specific situation and be able to provide more information than we can in this webinar. And I'll go ahead and send that information right now via chat about where someone can apply for our program.
Yeah, that makes sense. There's a lot more detailed analysis that will, I think, have to happen. Okay, so I think I can hand it over to Bisma now. There's nothing else.
Thank you, Jeremiah. Yeah, I will go over the UD process, the unlawful detainer process, which is the lawsuit that an eviction is called in court. I won't be able to see the questions because I'm on the slideshow, so I'll try to answer them at the end. But this is the rough timeline of the eviction process. It starts with a notice. The landlord would deliver a notice to the tenant, and usually it has a day written on the notice, 3 days, 30 days. But once those days have expired, then the landlord can file a lawsuit. And then you are served the paperwork that they file in court. The summons, which is summoning you to court, and then the rest is called the complaint, which will explain in better detail why they are evicting you. Once you receive that summons and complaint, you have 5 court days to respond. If you don't respond and you don't give your side of the story, then it immediately goes to default, which is a judgment against you. There's no trial, there's no nothing, and then you will be served a notice to vacate, and then the sheriff will lock you out. It's a very quick process, which is why it's so important to stake your claim, to file an answer, to give your side of the story within those 5 court days. After you file an answer, there'll be a notice of trial sent to you, and then there will be a trial. Of course, during all of this, if you and your landlord can settle, you should try and do that as well, and try and negotiate some terms. You don't necessarily have to wait for the judge to decide something. But then if you win the trial, then you get to stay. If you lose the trial, then again, you'll get a notice to vacate, and then the sheriff will lock you out. It's not the landlord that locks you out. So even if you do get that judgment against you, it still has to be the sheriff. So if the landlord locks you out, they're going to have their own fines and penalties. But it's a proper eviction when the sheriff comes and locks you out. Here is a more simplified version of that timeline, just to really emphasize how fast this process goes and how important it is to keep up with the deadlines. So you get a notice from the landlord. The event that the notice let's say the notice says that you haven't paid rent. It's a 3-day notice to pay. 3 days have passed and you haven't paid the rent. So that event triggering the notice hasn't been fixed and that notice has expired. Then the landlord can take their time, but pretty much they will file a UD, an unlawful detainer case, and then they will have to get someone to serve you that paperwork. So that's the summons and complaint. You will have to file that answer within the deadline, which is typically 5 court days. So it's not including weekends. And then after that, you wait for trial if there is no settlement. So it happens very fast. So a valid notice can look like a lot of different things, but it is a written document from the landlord to the tenant. Notices are the fairest document received in the eviction process, but they are not from the court, they're from the landlord. This basically gives the landlord that permission to go to court to file something. Here is a sample of what a notice may look like. Again, there can be a 3-day notice to pay or to quit, which means to move out. It can be a 3-day notice to perform covenants, which means a specific action that's usually specified in the lease agreement, or quit. An example of a covenant could be that you also have to pay the property, your share of the property expenses. Let's say you've been paying rent and everything, but you haven't been paying your share of the operating expenses. So they can say you have 3 days to fix this, or you can move out. And then once those 3 days pass, the landlord can go and file something in court. There can also be a notice that goes for 3 days, 30 days, or 60 days. Sometimes there can be no reason. It could be just that the lease expired, or they just want to move you out. And then sometimes there's lease designated notices, which have their very own deadline that's set forth in the lease. So as Jeremiah went over in best practices, that whatever's written in your lease, it's good to review that and see if there's any lease designated notices. And then any deadlines in that note in the lease govern over statutory deadlines, because the lease is a contract and you sign that contract, so you're agreeing to some modified things sometimes. Your notice might not actually look like that sample that was just up, because California doesn't require any specific format. They don't have their own notice document, so your landlord can really just type it up any way they want. There does have to be certain information included for the notice to be valid. So for example, a 3-day notice to pay rent has to include the date the demand was served on the tenant, the names and the addresses of the tenants, and the statement that the tenant owes rent and has to pay within 3 days, or the landlord will file an eviction. And there has to be the total amount of rent due and owed. It can be an estimate though. So if they, on the notice, it says $300 and you owe $350, it's not a reason enough to say that it's an invalid notice. So some hypotheticals of what your notices could look like, and then we'll go over whether they're valid or not. So let's say that your landlord serves you a handwritten note taped to your business's door, and all it says is, you owe 2 months of rent, pay tomorrow or you're evicted. Sometimes they can type a letter and just leave it in your mailbox, and it can say something like 3-day notice to pay rent or quit to Mr. Commercial Tenant. You missed the rent payments for 2 months for the business address. Pay the rent within 3 days or I will sue you. Something else that they can do possibly is type a typed letter that they hand deliver to the commercial tenant's 19-year-old son. March 20th, 2023, 3-day notice to pay rent or quit to Mr. Commercial Tenant. You missed the rent payments for 2 months for the property address. Pay the $5,000 for rent within 3 days or I will sue you. They all typically say around the same thing, but some of these are valid, some of these might not be valid. So the first one is missing the tenant's full name, the commercial property address. It's missing the estimate of how much is owed, and it also doesn't have the date that's served. So that would be an invalid notice. The second one, that's the letter that's left in the mailbox, is missing the estimate of how much money is owed and the date that the notice was served. So it's also invalid. And then the last one, all of the content in the notice is valid, but because it wasn't delivered directly to the tenant, a copy must be mailed to the tenant at their business address. So it could be valid, and you may say that it wasn't sent to me, so I'm not going to do anything about it. I'm going to sit on it. The landlord can't file anything, but double check your mailbox. Maybe there's something there at the commercial property address. But also at the same time, that even if all 3 notices were all invalid, any notice you ever get is invalid, it doesn't necessarily prevent an eviction. The landlord can still pursue the unlawful detainer case. The only thing that invalid notice could do is it could be a defense you raise in your answer, which could potentially throw out the lawsuit. Again, depends on what you're claiming is invalid about the notice, but the landlord can simply send a valid notice, wait for it to expire, and then file another lawsuit. So if you get a notice, again, because the eviction process is so fast and the notices usually are 3 days, sometimes they're 30 days, but when you're running a business, that can go by really fast. When you get a notice, the first thing you really want to do is get an attorney. You can apply to legal services for entrepreneurs as soon as possible to be matched with a pro bono attorney. I have the steps right here. You would visit our lccrsf.org. This is what the homepage looks like. You would just hover your mouse over Get Assistance on that top banner. You would go to Legal Services for Entrepreneurs, click on Commercial Tenant Legal Assistance. And then once you're on this page, you'll just scroll down until you get to our application. You would fill out all this information and then submit it, make sure you've submitted it. And then once you have applied, LSC will reach out for next steps. I know it can be kind of tricky to find the format. So this is how our process works. Sorry, just trying to switch the slide. And then the next step after the notice is that the landlord files something in court to start that eviction lawsuit, and you will get served that summons and complaint. So the first legal step, the active legal step that you would take in your unlawful detainer case is to file an answer within 5 court days of receiving that complaint. Again, 5 court days doesn't include court holidays or weekends. And if you fail to file that answer within those 5 court day deadlines, then you would get that default judgment from the court against yourself. And then you automatically lose. It doesn't matter if you had a slam dunk case. It doesn't matter the facts of the case. If you fail to file, then you lose, and the sheriff will lock you out of your space. That 5 court day deadline it does depend on how you were served the summons and complaint. Just like being served that notice, there are rules that apply to being served the summons and the complaint, which again is that court paperwork. So typically the 5 court day deadline applies if you are personally served, which is when someone over the age of 18 who's not involved in the lawsuit, so not the landlord or the property manager, directly serves you the eviction, the summons and complaint to you. So again, you're personally served, the paperwork is handed to you by an adult that's not involved in the lawsuit. That's when the 5 court day deadline applies. There is substituted service, is when the person delivering the summons and complaint leaves it with someone over the age of 18 because you can't be found at your business at the time of delivery. And then if this is used, then the person who is serving the paperwork, so the server, also has to mail a second copy to your business address. And then posting and mailing service is used when the person delivering the document either tapes it to your front door or leaves it somewhere easily visible on the property, because you can't be found or there's no one else, no adult working at your business that can be found to leave it with. And then if this process is used, again, the server has to mail a second copy to the party to be served at their business address. And so the 5 court day deadline applies for personal service. So if it's directly handed to you, again, the server can leave it at your feet. They can just leave it on the table. If there's a table between you, they don't physically have to hand it to you. That personal service still applies. But if those other 2 services, substituted or posting and mailing, is used, then the summons and complaint are considered served 10 calendar days after that second copy is mailed, after which the tenant has 5 court days to file its answer, which is a lot of words, it's a lot of numbers. So I'm going to explain that with a hypothetical. So if we're just sticking to personal service, someone who's not the landlord and is an adult hands you the summons and complaint on December 19th, you then want to count 5 court days to see when your answer is due. So you get served Tuesday the 19th, the 20th is one day, the 21st is the second, 22nd is the third day, and then you skip Saturday and you skip Sunday. You're also skipping Monday because it's a holiday. So then your 4th day is Tuesday, December 26th, and then your final day to file an answer is Wednesday, December 27th. You can go ahead and file on Wednesday, December 20th. You don't have to wait till the 27th, but that's your very last day to file an answer if you are personally served. So you technically have more than 5 days because you're counting the Mondays off and you have Saturday and Sunday, but that's what court days look like. So if we're using the same hypothetical, but your substituted service was used on December 7th, so someone other than you was handed, or other than the tenant was handed the paperwork on December 7th, and then the second copy was mailed December 9th, then you kind of want to disregard the December 7th date and just focus on December 9th when it was mailed. And you're going to count 10 days, calendar days, so including the weekends and the holidays, to see when it would be considered served. So it's considered served on December 19th. And just like the personal service hypothetical, your answer would be due December 27th. And then if posting and mailing service was used, again, you want to look at the date that it was mailed and then count 10 calendar days to see when it would be considered served, just so that the court wants to allow you time for the summons and complaint to go through the mail and for you to really show that you've gotten it. That's why it's 10 calendar days that you look to find the service date, and then you go the 5 court days to give you that time to file that answer. So once you have the summons and complaint, you've figured out your deadline, you want to file the answer, but an answer is part of, two things are part of an answer. There's the denials, and then there's affirmative defenses. A denial can either be general or specific. So any statement that the tenant doesn't deny or say that they are unsure about is going to be accepted as true by the court, and the tenant cannot argue against it later. You can do a general denial if the complaint says you owe less than $1,000. So let's say you're behind on rent, but your rent is only $900. In some world, that's the case. Then you can just say that you deny all statements in the complaint by checking box 2A on the UD 105 form. Your answer is going to be like a court template. Maybe this box is different now. I haven't checked, but sometimes it looks different depending on the court system as well. But it's a general denial will just be you marking one box. If you owe more than 1,000, then you have to individually deny applicable statements, accept some statements as true, or mark that you're unsure of them. And that's if you owe more than 1,000. So the second part of an answer is an affirmative defense. There are 3 important things to keep in mind about the defenses that you choose to raise. So if a defense is stated, you still have to prove it at the trial. So you have to present evidence and show facts that the defense is based on. You can raise the defense in your answer, and if you do, you have to argue it at trial. If you fail to raise that defense, then you cannot argue it. So if it's not in your answer, you can't bring it up in trial. But let's say you forgot or you didn't realize that it was relevant or it didn't come up when you filed your answer, you can have an option to file an amended answer. So all is not lost, but you do want to make sure that in your first answer, you're really thinking it through about what you would possibly want to raise. And again, all defenses must be stated in the answer to be considered at trial. Here is an example of an affirmative defense. Again, affirmative defenses require that the tenant present facts and prove that the defenses apply. So retaliatory eviction is one affirmative defense in an unlawful detainer case. Examples could include that a landlord raises the rent after a tenant has complained about problems with their rental. And then you would have to show facts that you asserted your rights, when you asserted those rights, and how the tenant or how the landlord immediately served you with a notice of eviction. So if your roof was leaking and you complained to the landlord, and then immediately after the landlord is trying to kick you out, again, you would show that you have proof that you asked the landlord for those repairs. So do you want to have all your communications in writing? And then you want to show that immediately after you were served with that eviction. So that's how you would raise a retaliatory eviction defense. And then the next steps in a unlawful detainer lawsuit is once you filed your answer, there will be a notice of trial sent by the court after a trial date has been requested. And then in the next few weeks, a trial will be held. If the landlord wins, the sheriff will lock you out, not the landlord. And then during all of this, you can request to meet with your landlord and try to negotiate and come to a settlement. They might do the same with you. So don't feel like you have to stick by what the judge says. If you think you can work this out with the landlord, then you have the right to do that as well. And then we also have this unlawful detainer guide for small business owners. So if you ever want to study more about, what your possible defenses could be, you want to see what the court forms look like, you can visit the LCCRSF website, you can scan the QR code, and it can just explain things a little more in depth if you ever feel like you need to brush up on your unlawful detainer guide, your unlawful detainer info. Yeah, I think that's it.
Thank you, Bisma and Jeremiah, for all that information. I know there were some questions about our legal services in the chat, so I'll go ahead and just review that really quickly. We provide short and longer term assistance, and it is there is no charge to support you on your commercial lease issue. All you need to do is apply to our program. We do have some requirements for the clients that we take on. But if we cannot help you, we will look for a referral for you. And so just go ahead and apply to these links. If you think you have another commercial lease issue, and then we will have a legal clinic this month on May 25th. And you can go ahead and register for that as well through the link that I'm about to send. All of the information presented today will be available this week through the registration email that you sent. And you can go ahead and be able to view the webinar in whatever language you need it. And then we'll also be able to see the presentation slides as all the presentations were translated as well. So feel free to be in touch with us. If you have a commercial lease issue, we are happy to help and find an attorney that can help you review your lease. Or if you also need to draft up a lease, we also have attorneys that can help with that. Negotiations as well. And if there is an unlawful eviction, then we can go ahead and support with that as well. Yeah, thank you so much for coming to the webinar today. We hope this was helpful. Let me just review and make sure I know there's 2 questions that came up.
Yeah, I was gonna say, are we gonna answer any questions at this point?
Yeah, so there is one question about negotiating a CAM fee.
Yeah, I can take that. And there was actually, I saw a question in the chat from earlier that we didn't address, so we can address that too.
Okay, got it. Let me look for that one.
So it was the first question in the chat. So the chat question just asked about how much cash do small businesses generally need to put down to secure a lease? In my case, 501c3. This is totally a business question, not really a legal issue. And the decision by the landlord is usually going to be based on what they believe the creditworthiness of the tenant, and when they underwrite the deal. So how much risk do they think there is that there's going to be an issue that they might have to pay something, and what do they need in order to feel secure? And that amount can span, nothing to a lot. It's typically not going to be like, your whole lease payment, your whole rent payment, but it could be big. It could be a year's worth of rent or something like that. But again, if you're a big organization, or you have a big organization behind you, they may take no cash down, especially if you're willing to do something else, like provide a guarantee, or sometimes they take a letter of credit instead of cash. So it's something to think about in the negotiation part. And when you're writing your lease, the thing to think about is whatever you agreed to and put down in writing is the thing that you'll be obligated to do. So if you want to look at alternatives, or have potential alternatives for the future, maybe work that into your lease when you're negotiating it up front. Okay, and then the other question was, can you negotiate CAM fees, and how? Yes, you can absolutely negotiate CAM fees. Often this is a highly negotiated term. A lot of times you actually see a huge long list. It'll say tenant is responsible for all their tenant's proportionate share of all operating fees of the building, something like that. And then it may say those fees include but are not limited to, and then they'll have like 50 things listed. And then if you are a tenant who's negotiating and you have an ability to push back on that, they would say includes 1 through 50, and you'd say, and notwithstanding the above, it excludes, and you'd kind of list a whole bunch of things yourself that you'd want to make sure that they don't wrap into it, no matter what's said above. That's kind of the easiest way to do it, rather than saying strike this, strike this, strike this. You just say, notwithstanding the above, your common area maintenance fees will not include, if it's a big company, it could be like upper level management salaries, and or it could be, you know, works of art or something like that that you want to cut out, or excessive utility use by other tenants, something like that. So yes, you can absolutely negotiate that. Any other questions? No?
Seeing any more questions in the chat or the Q&A, Jeremiah and Bisma. So we can go ahead and end there.
Thanks. Thanks, everyone.
Thank you so much, everyone. And you will get the a copy of the slides as well as the webinar recording today, later this week. All right. Bye.
Thanks, Anna. Bye.
Bye.